So there were recently two rulings in the Supreme Court challenging the liability or responsibility of social media companies when terrorists or ISIS use their services in the planning and commencement of an attack. Is that enough to give them some kind of legal liability under the law? Now, a big question was whether Communications Decency Act Section 230 would shield them from that. The short answer is no. The court reached this outcome without touching the Communications Decency Act or Section 230. In fact, you're going to see a lot of discussion about a different number 23, Section 2333 of 18 U.S.C., which of course is not the Communications Decency Act. Now, this is a unanimous opinion of the court. There is no political controversy of which party voted for which and why. You've got all of the justices voting for the same outcome, and there's a concurring opinion at the end, and this case will affect the other case because there were two of them. Gonzalez was the other one, and Taamneh, Taamneh, is this one. This is the substantial opinion, the one with about 30 pages, and the other opinion is just a 3-pager that refers to this opinion. So, without further ado, and noting that Justice Thomas writes the opinion for the court, the Supreme Court writes, under 18 U.S.C. Section 2333, U.S. nationals who have been injured by reason of an act of international terrorism may sue for damages. They are not limited to suing the individual terrorists or organizations that directly carried out the attack. This is because the law imposes civil liability on any person who aids and abets by knowingly providing substantial assistance, or who conspires with the person who committed such an act of international terrorism. So we're looking for aids and abets, knowingly providing substantial assistance, or conspiracy with the person who committed the act. Victims of terrorist acts, therefore, may seek to recover from those who aided and abetted the terrorist act that injured them. The plaintiffs, who are respondents Taamneh here, claim that they were allegedly injured by a terrorist attack carried out by ISIS, but the plaintiffs are not suing ISIS. Instead, they have brought suit against 3 of the largest social media companies in the world, Facebook, Twitter, and Google, for allegedly aiding and abetting ISIS. As plaintiffs allege, ISIS has used defendants' social media platforms to recruit new terrorists and to raise funds for terrorism. Defendants allegedly knew that ISIS was using their platforms but failed to stop it from doing so. Plaintiffs accordingly seek to hold Facebook, Twitter, and Google liable for the terrorist attack that allegedly injured them. We conclude, however, that plaintiffs' allegations are insufficient to establish that the defendants aided and abetted ISIS in carrying out the relevant attack. 1. Plaintiff's case arises from a 2017 terrorist attack on the Rina nightclub in Istanbul, Turkey. The attack was carried out by, Abdul Qadir Mashirapov on behalf of the Islamic State of Iraq and Syria, ISIS. Born in Uzbekistan, Mashirapov has received military training with al-Qaeda in Afghanistan in 2011 and eventually became affiliated with ISIS. In 2016, he was ordered by ISIS to travel to Turkey and launch an attack in Istanbul on New Year's Eve. After planning and coordinating the attack with ISIS Emir Abdu Shuhada, Mashirapov entered the Rina nightclub in the early hours of January 1, 2017, and fired over 120 rounds into a crowd of more than 700 people. In total, he killed 39 people and injured 69 others. The next day, ISIS released a statement claiming responsibility for the attack. 2 weeks later, Mashirapov was arrested in Istanbul after hiding out in ISIS safe houses. One of Mashirapov's victims was Nauras Alasov, who was killed in the attack. Several members of Alasov's family then brought the present lawsuit under Section 2333, alleging that they had been injured by the attack. Invoking subsection D2, plaintiffs sued 3 major social media companies, claiming that they aided and abetted ISIS and thus were liable for the Rina nightclub attack. As is common knowledge, these 3 companies control 3 of the largest and most ubiquitous platforms on the internet: Facebook, YouTube, and Twitter. At the time of the Rena attack, Facebook had over 2 billion active users each month, YouTube had over 1 billion, and Twitter had around 330 million. Everyone before us today agrees on the basic aspects of these platforms' business models. People from around the world can sign up for the platforms and start posting content on them free of charge and without much, if any, advanced screening by defendants. Once on the platforms, users can upload messages, videos, and other types of content, which others on the platform can then view, respond to, and share. As noted above, billions of people have done just that. As a result, the amount of content on defendants' platforms is staggering. It appears that for every minute of the day, approximately 500 hours of video are uploaded to YouTube, 510,000 comments are posted on Facebook, and 347,000 tweets are sent on Twitter. And that was every minute. Defendants profit from this content largely by charging third parties to advertise on their platforms. Those advertisements are placed on or near the billions of videos, posts, comments, and tweets uploaded by the platform's users. To organize and present all those advertisements and pieces of content, defendants have developed recommendation algorithms that automatically match advertisements and content with each user. The algorithms generate those outputs based on a wide range of information about the user, the advertisement, and the content being viewed. So, for example, a person who watches cooking shows on YouTube is more likely to see cooking-based shows and advertisements for cookbooks, whereas someone who likes to watch professorial lectures might see collegiate debates and advertisements for TED Talks. I don't get collegiate debates and advertisements for TED Talks. I don't know if that says more about me or more about them. But not all of the content on defendants' platforms is so benign. As plaintiffs allege, ISIS and its adherents have used these platforms for years as tools for recruiting, fundraising, and spreading their propaganda. Like many others around the world, ISIS and its supporters opened accounts on Facebook, YouTube, and Twitter and uploaded videos and messages for others to see. Like most other content on these platforms, their videos and messages were then matched with other users based on those users' information and history. And like most other content, advertisements were displayed with ISIS messages, posts, and videos based on information about the viewer and the content being viewed. Can you imagine just using Facebook like normally and you start to get these like posts in your feed from ISIS? Like, what does Facebook think about me that like I'm getting these hypothetically in my feed, right? Like, I would be a little freaked out. Unlike most other content, however, ISIS videos and messages celebrated terrorism and recruited new terrorists. For example, ISIS uploaded videos that fundraised for weapons of terror and that showed brutal executions of soldiers and civilians alike. I'm laughing because it's so horrible. And plaintiffs allege that these platforms have been crucial to ISIS growth, allowing it to reach new audiences, gain new members, and spread its message of terror. It's just absolutely absurd thinking about, ISIS members going on to like Facebook and like uploading their message of terror. Obviously, it happens. It's horrible. It's just it's so absurd. I grew up in a world without the possibility of that, and then we created something that allowed that to happen as sort of a side effect, and it's just absolutely absurd. Plaintiffs also allege that defendants have known that ISIS used their platform for years. Yet plaintiffs claim that defendants have failed to detect and remove a substantial number of ISIS-related accounts, posts, and videos. For example, plaintiffs aver that defendants have failed to implement a basic account detection methodology to prevent ISIS supporters from generating multiple accounts on their platform. Accordingly, plaintiffs assert that defendants aided and abetted ISIS by knowingly allowing ISIS and its supporters to use their platforms and benefit from the recommendation algorithms, enabling ISIS to connect with the broader public, fundraise, and radicalize new recruits. And in the process, defendants allegedly have profited from the advertisements placed on ISIS tweets, posts, and videos. Plaintiffs also provide a set of allegations specific to Google. Google has established a system that shares revenue gained from certain advertisements on YouTube videos. Okay, so similar accusation there. The district court, the lower court, dismissed plaintiffs' complaint for failing to state a claim, so 12b6. But the Ninth Circuit reversed. finding that the plaintiffs had plausibly alleged that defendants aided and abetted ISIS within the meaning of the law and thus could be held secondarily liable for the Rena nightclub attack. Guys, this is critical. I'm not sure if you all caught this. If you didn't catch it, that's fine. That was a difficult catch. But this changes the entire posture of the case. So let's go over this paragraph. This is a critical paragraph. The district court dismissed plaintiff's claim for failure to state a claim. What does that mean? That means we're at the beginning of the case. The plaintiff filed a claim and then it was dismissed. It was challenged and dismissed immediately. There was no adjudication on the merits. And the Ninth Circuit did not grant an adjudication on the merits directly. Instead, they reversed, saying it shouldn't be dismissed on this motion to dismiss. So the Ninth Circuit said that there was a plausible allegation, plausibility under Federal Rules of Procedure 8, that you need to plausibly allege the allegations and not just the mere possibility of things connecting and happening, but plausibly, something higher than possibly. It's a difficult standard to really articulate. I still struggle with it. But the Ninth Circuit reversed on a motion to dismiss. So in my opinion, that doesn't mean the Ninth Circuit would have held Twitter liable or would have held Facebook liable. They would have at least given the plaintiff a chance to prove their case. Whereas now the Supreme Court is saying, no, the district court was correct. This didn't state a claim. So as we're going forward and reading the rest of this thing, you have to remember, it's absolutely critical to remember that the justices are ruling at the motion to dismiss stage, that the plaintiff didn't connect the dots enough to get to a further court proceeding, to full litigation and then adjudication before a judge or jury. We're skipping or stopping short of going forward because there wasn't enough of a connection. And the Ninth Circuit said, yeah, maybe let's at least hear what the plaintiff has to say in the legal sense, that they did plausibly allege something. And the Supreme Court's going to tell us why that was wrong. So here's Section 2 about the law. Section 2333 was originally enacted as part of the Anti-Terrorism Act in 1990. At that time, Congress authorized U.S. nationals or their estate, survivors, or heirs to bring civil lawsuits when injured in their person, property, or business by reason of an act of international terrorism. In such a lawsuit, the plaintiff could recover treble damages and the cost of the suit, including attorney's fees. But the ATA did not explicitly impose liability on anyone who helped the terrorists carry out the attack or conspired with them. Prior to 2016, some courts accordingly determined that the ATA did not authorize that sort of secondary civil liability. Then, in 2016, Congress enacted the Justice Against Sponsors of Terrorism Act, JASTA, to provide for a form of secondary civil liability. Thus, as the law now stands, those injured by an act of international terrorism can sue the relevant terrorists directly, or they can sue anyone who aids and abets, or conspires with, or knowingly provides substantial assistance to. For such a secondary liability claim, there is an additional condition. The act of international terrorism must have been, quote, committed, planned, or authorized by an organization that had been designated as a foreign terrorist organization as of the date on which such act of international terrorism was committed, planned, or authorized. Plaintiffs seeking secondary liability can likewise recover treble or triple damages and the cost of the suit, including attorney's fees. The parties here do not dispute that the first three components have been adequately alleged. The Rena nightclub attack was an act of international terrorism. The act was committed, planned, or authorized by ISIS, and ISIS was designated as a foreign terrorist organization as of the date of the Rena nightclub attack. The essential question is thus whether defendants' conduct constitutes aiding and abetting by knowingly providing substantial assistance, such that they can be held liable for the Rena nightclub attack. As always, we start with the text of the law, Section 3 here. Here, that text immediately begs two questions. First, what exactly does it mean to aid and abet? Second, what precisely must the defendant have aided and abetted? So here's the two questions we need to answer. We turn first to the meaning of the phrase aids and abets by knowingly providing substantial assistance. Nothing in the statute defines any of those critical terms. Yet terms like aids and abets are familiar to the common law, which has long held aiders and abettors secondarily liable for the wrongful acts of others. We generally presume that such common law terms bring the old soil with them. In enacting JosuÄ, Congress provided additional context by pointing to the case of Halberstam versus Welch from 1983 as providing the proper legal framework for civil aiding and abetting and conspiracy liability. We thus begin with Halberstam's legal framework, viewed in the context of the common law tradition from which it arose. Long regarded as a leading case on civil aiding and abetting and conspiracy liability, Halberstam arose from a distinctive fact pattern. Bernard Welch was a serial burglar who had killed Michael Halberstam during a break-in. Halberstam's estate then sued Welch's live-in partner, Linda Hamilton, for aiding and abetting and conspiring with Welch. Hamilton was not present for Halberstam's murder, or even allegedly aware of the murder. But the facts made clear that she was a willing partner in Welch's criminal activities. Hamilton had lived with Welch for 5 years, during which time the couple had risen from modest circumstances to possess a substantial fortune. This rapid ascent was remarkable because Welch had no outside employment. Rather, he left the house most evenings and returned with antiques, jewelry, and precious metals, some of which he melted down into gold and silver ingots by using a smelting furnace that he had installed in their garage. Meanwhile, Hamilton did the bookkeeping work for Welch's business, facilitating the sale of those stolen goods. She had Welch's customers make checks payable to her, falsified her tax returns at Welch's direction, and kept records of incoming payments from Welch's customers, with no records of outgoing funds to his suppliers. Their arrangements continued until Welch was arrested after he killed Halberstam while burglarizing Halberstam's home. To determine Hamilton's liability, the D.C. Circuit undertook an extensive survey of the common law, examining a series of state and federal cases, the Restatement Second of Torts, and prominent treatises that discussed secondary liability in tort. Those are sort of summaries of the law. If you're not familiar with the Restatement Second of Torts or prominent treatises, those are summaries of the law written by professionals, lawyers with a lot of lawyers or researchers with a lot of understanding and knowledge and ability to organize the law. The good ones are well known for being able to summarize everything very well. So judges and lawyers will often turn to a treatise first. It's kind of like a Wikipedia of the law. It's not the law, but it's a really good summary of it. So you won't cite the Restatement Second of Torts as the law, but you might say, the Restatement Second of Torts stands for this principle, and then here's a bunch of cases that dealt with that principle. And the judge will know, or your opposing party will know that, hey, maybe the Restatement Second of Torts isn't the law, but we know that an expert wrote it who was pretty good at understanding it. So if they said something, we should at least listen. It's kind of like that. It's a good Wikipedia of the law as an analogy. With respect to aiding and abetting, the court synthesized the cases as resting on 3 main elements. First, the party whom the defendant aids must perform a wrongful act that causes an injury. Second, the defendant must be generally aware of his role as part of an overall illegal or tortious activity at the time that he provides the assistance. And third, the defendant must knowingly and substantially assist the principal violation. Halberstam then articulated 6 factors to help determine whether a defendant's assistance was substantial. This is very typical of the law. We have 3 factors up here, one of those breaks out into 6. Those factors are 1, the nature of the act assisted, 2, the amount of assistance provided, 3, whether the defendant was present at the time, 4, the defendant's relation to the tortious actor, 5, the defendant's state of mind, and 6, the duration of the assistance. Last, Halberstam clarified that those who aid and abet a tortious act may be liable not only for the act itself, but also for other reasonably foreseeable acts done in connection with it. This is the felony murder rule. If you commit a murder in the commission of a felony, or if a murder occurs during the commission of a felony, you are liable for it. If you cause a police situation and the police shoot at you and they hit a bystander, you can get charged with murder. Applying that framework, the D.C. Circuit held that Hamilton was liable for aiding and abetting Halbertstam's murder. The court first determined that Welch had committed a wrong in killing Halbertstam during the burglary, and that Hamilton was generally aware of her role in Welch's criminal enterprise. It then explained that Hamilton had given knowledge and substantial assistance to Welch's activities by helping him turn his stolen goods into legitimate wealth, thereby intending to help Welch succeed by performing a function crucial to any thief. And it clarified that Hamilton knew Welch was committing some sort of personal property crime, the foreseeable risk of which was violence and killing. The court therefore concluded that Hamilton substantially helped Welch commit a personal property crime and was liable for Halbertstam's death, which was a foreseeable result of such crimes. That articulation of the common law thus resolved Halbertstam. But Halbertstam the case recognized that the elements and factors it provided could be merged or articulated somewhat differently without affecting their basic thrust. It thus cautioned in a typical common law fashion that its formulations should not be accepted as immutable components. Rather, Halbertstam suggested that its framework should be adopted as new cases test their usefulness in evaluating vicarious liability. The allegations before us today are a far cry from the facts of Halbertstam. Rather than dealing with a serial burglar and his live-in partner in crime, we are faced with international terrorist networks and world-spanning internet platforms. By Halbertstam's own lights, its precise 3-element and 6-factor test may not be entirely adequate to resolve these new facts. And JosuÄ itself points only to Halbertstam's framework, not its facts or its exact phrasings and formulations, as the benchmark for aiding and abetting. We must ascertain the basic thrust of Halbertstam's elements and determine how to adapt its framework to the facts before us today. To do so, we turn to the common law of aiding and abetting on which Halbertstam rested and to which JosuÄ's common law terminology points. So now he's going to go back even further in the common law. As we have recognized, aiding and abetting is an ancient criminal law doctrine that has substantially influenced its analog in tort. In one early statement of the criminal law doctrine, William Blackstone explained that those who were present aiding and abetting the fact to be done, or procured, counseled, or commanded another to commit a crime, were guilty and punishable. Over the years, many statutes and courts have offered variations on that basic rule, yet to this day the basic view of culpability that animates the doctrine is straightforward. A person may be responsible for a crime he has not personally carried out if he helps another to complete its commission. Importantly, the concept of helping in the commission of a crime or a tort has never been boundless. That is because, if it were, aiding and abetting liability could sweep in innocent bystanders as well as those who gave only tangential assistance. For example, assume that any assistance of any kind were sufficient to create liability, hypothetically. If that were the case, then anyone who passively watched a robbery could be said to commit aiding and abetting by failing to call the police. Yet our legal system generally does not impose liability for mere omissions, inactions, or nonfeasance, although inaction can be culpable in the face of some independent duty to act. The law does not impose a generalized duty to rescue. Moreover, both criminal and tort law typically sanction only wrongful conduct, bad acts, misfeasance. Some level of blameworthiness is therefore ordinarily required. But again, if aiding and abetting liability were taken too far, then ordinary merchants could become liability for any misuse of their goods and services, no matter how attenuated their relationship with the wrongdoer. And those who merely deliver mail or transmit emails could be liable for the tortious messages contained therein. For these reasons, courts have long recognized the need to cabin aiding and abetting liability to cases of truly culpable conduct. They have cautioned, for example, that not all those present at the commission of a trespass are liable as principals merely because they make no opposition or manifest no disapprobation of the wrongful acts of another. Put another way, overly broad liability would allow for one person to be made a trespasser and even a felon against his or her consent, and by the mere rashness or precipitancy or overheated zeal of another. Moreover, unlike its close cousin conspiracy, aiding and abetting does not require any agreement with the primary wrongdoer to commit wrongful acts, thus eliminating a significant limiting principle. To keep aiding and abetting liability grounded in culpable misconduct, criminal law thus requires that a defendant in some sort associate himself with the venture, that he participate in it as in something that he wishes to bring about, that he seek by his action to make it succeed, before he could be held liable. In other words, the defendant has to take some affirmative act with the intent of facilitating the offense's commission. Such intentional participation can come in many forms, including abetting, inducing, encouraging, soliciting, or advising the commission of the offense, such as through words of encouragement or driving the getaway car. Regardless of the particulars, however, it is clear that some culpable conduct is needed. Similar principles and concerns have shaped aiding and abetting doctrine in tort law, with numerous cases directly employing them to help articulate the standard for tortious aiding and abetting. Similar to the criminal law rule, some cases have required that the defendant's assistance must have had a direct relation to the trespass and have been calculated and intended to produce it to warrant liability for the resulting tort. Other cases have emphasized the need for some culpable conduct and some degree of knowledge that a defendant's actions are aiding the primary violator before holding the defendant secondarily liable. Still others have explained that culpability of some sort is necessary to justify punishment of a secondary actor, lest mostly passive actors like banks become liable for all of their customers' crimes by virtue of carrying out routine transactions. And others have suggested that inaction cannot create liability as an aider and abettor absent a duty to act. In articulating those limits, courts simultaneously began to crystallize the framework for aiding and abetting that Halberstam identified and applied. As in Halberstam, that framework generally required what the text of our Law 2333 demands, that the defendants have given knowing and substantial assistance to the primary tortfeasor. Notably, courts have viewed these twin requirements as working in tandem, with a lesser showing of one demanding a greater showing of another. In other words, less substantial assistance required more scienter or knowledge before a court could infer conscious and culpable assistance. And vice versa, if the assistance were direct and extraordinary, then a court might readily infer conscious participation in the underlying tort. In moving back and forth between all these guideposts, the court thus largely tracked the same distinctions drawn above to ensure that liability fell only on those who had abetted the underlying tort through conscious, culpable conduct. Halberstam's framework reflected and distilled those common law principles. Indeed, Halberstam started with a survey of many earlier common law cases, including many of the same cases cited above: Woodward, Landy, Duke, Halberstam. For example, Halberstam recognized that giving verbal encouragement, such as yelling, "Kill him," I guess during a fight, could be substantial assistance, but that passively watching an assault after hearing an assailant threaten the victim likely would not be. Those same lines have long been drawn for aiding and abetting liability under common law. And Halberstam's 6 factors for substantial assistance call for the same balancing the courts had undertaken previously between the nature and amount of assistance on the one hand and the defendant's scienter on the other. Despite that deep-rooted common law basis, the Ninth Circuit appears to have undertook justice approval of Halberstam's legal framework as requiring it to hew tightly to the precise formulations that Halberstam used. Okay, so the Supreme Court's saying that the Ninth Circuit applied Halberstam, and they just did it wrongly. Let's see. The parties before us similarly make a conscious effort to draw analogs to the facts of the case. But any approach that too rigidly focuses on Halberstam's facts or its exact phraseology risks missing the mark. Halberstam is, by its own terms, a common law case and provided its elements and factors as a way to synthesize the common law approach to aiding and abetting. And JosuÄ employs the common law terms, aids and abets, pointing to Halberstam's common law framework as the primary guidepost for understanding the scope of 2333. At bottom, both JosuÄ and Halberstam's elements and factors rest on the same conceptual core that has animated aiding and abetting liability for centuries, that the defendant consciously and culpably participated in a wrongful act so as to help make it succeed. To be sure, nuances may establish daylight between the rules for aiding and abetting in criminal and tort law. We have described the doctrines as roughly similar, not identical. But we need not resolve the extent of those differences today. It is enough for our purposes to recognize the framework that Halberstam set forth and the basis on which it rests. The phrase aids and abets in 2333d2, as elsewhere, refers to a conscious, voluntary, and culpable participation in another's wrongdoing. The next question, however, is what precisely a defendant must aid and abet. As noted above, JosuÄ imposes liability on anyone who aids and abets by knowingly providing substantial assistance or who conspires with the person who committed such an act of international terrorism. The parties vigorously dispute the textual object of the term aids and abets. Plaintiffs assert that it is the person, and defendants insist that it is the act. So plaintiffs contend defendants can be liable if they aided and abetted ISIS generally. There is no need for defendants to have aided and abetted the specific Rena nightclub attack. Conversely, defendants posit that they are only liable if they directly aided and abetted the Rena nightclub attack, with a strict nexus between their assistance and that attack. Neither side is quite right. To start, we find it unnecessary to parse whether the textual object of aids and abets is the person or the act. That syntactic dispute makes little difference here because aiding and abetting is inherently a rule of secondary liability for specific wrongful acts. As stated above, the rule imposes liability for a wrong on those who help another complete its commission, or as Halberstam put it, the defendant must aid and abet a tortious act. Nor would a contrary rule make sense for torts. That is because tort law imposes liability only when someone commits an actual tort. Merely agreeing to commit a tort or suggesting a tortious act is not, without more, tortious. Enterprises or conspiracies alone are therefore not tortious. The focus must remain on the tort itself. The same is true here. The ATA opens the courthouse doors only if the plaintiff is injured by reason of an act of international terrorism. JosuÄ further restricts secondary liability by requiring that the act of international terrorism be committed, planned, or authorized by a foreign terrorist organization designated as such. Thus, it is not enough, as plaintiffs contend, that a defendant have given substantial assistance to a transcendent enterprise separate from and floating above all the actionable wrongs that constitute it. Rather, a defendant must have aided and abetted by knowingly providing substantial assistance another person in the commission of the actionable wrong, here an act of international terrorism. So it's both. You need a person and an act. Plaintiffs insist that Halberstam proves the contrary, but their argument misses the gist of that case. To be sure, Linda Hamilton was not on the scene for the burglary of Halberstam's house and did not lend any specific support to Halberstam's murder. But Hamilton's assistance to Welch was so intentional and systematic that she assisted each and every burglary committed by Welch. Any time that Welch left the house to burglarize, he would have relied on Hamilton's assistance in laundering the stolen goods and transforming them into useful wealth. Thus, Hamilton did aid and abet Welch in burglarizing Halberstam's home, and as noted above, killing Halberstam was a foreseeable consequence of that burglary. On the other hand, defendants overstate the nexus that 2333d2 requires between the alleged assistance and the wrongful act. To start, aiding and abetting does not require the defendant to have known all particulars of the primary actor's plan. For example, a defendant might be held liable for aiding and abetting the burning of a building if he intentionally helped others break into the building at night and then, unknown to him, the others lit torches to guide them through the dark and started a fire. That leads to the next problem. As Halberstam makes clear, people who aid and abet a tort can be held liable for other torts that were a foreseeable risk of the intended tort. Accordingly, a close nexus between the assistance and the tort might help establish that the defendant aided and abetted the tort, but even more remote support can still constitute aiding and abetting in the right case. Moreover, in appropriate circumstances, a secondary defendant's role in an illicit enterprise can be so systemic that the secondary defendant is aiding and abetting every wrongful act committed by that enterprise, as in Halbertstam itself. At this point, aiding and abetting liability begins to blur with conspiracy liability, which typically holds co-conspirators liable for all reasonably foreseeable acts taken to further the conspiracy. Yet, as noted above, aiding and abetting lacks the requisite agreement that justifies such extensive conspiracy liability. Thus, while the facts of Halbertstam are not totemic, lest courts strain to compare Linda Hamilton with international criminal syndicates, its facts are useful when determining whether a defendant has so consciously participated in a series of tortious acts in order to make each one succeed. To summarize, the requirements of 2333d2, our law here, the phrase aids and abets by knowingly providing substantial assistance points to the elements and factors articulated by Halbertstam, but those elements and factors should not be taken as inflexible codes. Rather, they should be understood in light of the common law and applied as a framework designed to hold defendants liable when they consciously and culpably participate in a tortious act in such a way as to help make it succeed. And the text requires that defendants have aided and abetted the act of international terrorism that injured the plaintiffs, though that requirement does not always demand a strict nexus between the alleged assistance and the terrorist act. Section 4. Under the appropriate framework, some respects of today's case become immediately clear. First, because they are trying to hold defendants liable for the Rena attack, plaintiffs must plausibly allege that defendants aided and abetted ISIS in carrying out that attack. Next, plaintiffs have satisfied Halbertstam's first two elements by alleging that ISIS both committed a wrong and that defendants knew they were playing some sort of role in ISIS's enterprise. The key question, therefore, is whether defendants gave such knowing and substantial assistance to ISIS that they culpably participated in the Rena attack. The allegations here fall short of that showing under Halbertstam's framework as properly understood by reference to the common law principles it applied. To start, recall the basic ways that defendants as a group allegedly helped ISIS. First, ISIS was active on defendants' social media platforms, which are generally available to the internet using public with little to no front-end screening by defendants. In other words, ISIS was able to upload content to the platforms and connect with third parties just like everyone else. Second, defendants' recommendation algorithms matched ISIS-related content to users most likely to be interested in that content, again, just like any other content. And third, defendants allegedly knew that ISIS was uploading this content to such effect, but took insufficient steps to ensure that ISIS supporters and ISIS-related content were removed from their platforms. Notably, plaintiffs never allege that ISIS used defendants' platforms to plan or coordinate the Rena attack. In fact, they do not allege that Musharrapov himself ever used Facebook, YouTube, or Twitter. None of these allegations suggest that defendants culpably associated themselves with the Rena attack, participated in it as something that they wished to bring about, or sought by their action to make it succeed. In part, that is because the only affirmative conduct defendants allegedly undertook was creating their platforms and setting up their algorithms to display content relevant to user inputs and user history. Plaintiffs never allege that, after defendants established their platforms, they gave ISIS any special treatment or words of encouragement. Nor is there reason to think that defendants selected or took any action at all with respect to ISIS's content, except perhaps blocking some of it. Indeed, there is not even reason to think that defendants carefully screened any content before allowing users to upload it onto their platforms. If anything, the opposite is true. By plaintiffs' own allegations, these platforms appear to transmit most content without inspecting it. The mere creation of these platforms, however, is not culpable. To be sure, it might be that bad actors like ISIS are able to use platforms like defendants for illegal and sometimes terrible ends, but the same could be said of cell phones, email, or the internet generally. Yet we do not think that internet or cell phone service providers incur culpability merely for providing their services to the public writ large. Nor do we think that such providers would normally be described as aiding and abetting, for example, illegal drug deals brokered over cell phones, even if the provider's conference call or video call features made the sale easier. To be sure, plaintiffs assert that defendants' recommendation algorithms go beyond passive aid and constitute active substantial assistance. We disagree. By plaintiffs' own telling, their claim is based on defendants' provision of the infrastructure which provides material support to ISIS. Viewed properly, defendants' recommendation algorithms are merely part of the infrastructure. All the content on their platforms is filtered through these algorithms, which allegedly sort the content by information and inputs provided by the users and found in the content itself. As presented here, the algorithms appear agnostic as to the nature of the content, matching any content, including ISIS content, with any user who is more likely to view that content. The fact that these algorithms matched some ISIS content with some users does not convert defendants' passive assistance into active abetting. Once the platform and sorting tool algorithms were up and running, defendants at most allegedly stood back and watched. They are not alleged to have taken any further action with respect to ISIS. At bottom, then, the claim here rests less on affirmative misconduct and more on an alleged failure to stop ISIS from using the platforms. But as noted above, both tort and criminal law have long been leery of imposing aiding and abetting liability for mere passive nonfeasance. To show that defendants' failure to stop ISIS from using these platforms is somehow culpable with respect to the RENA attack, a strong showing of assistance and scienter or knowledge would thus be required. Plaintiffs have not made that showing. First, the relationship between defendants and the RENA attack is highly attenuated. As noted above, defendants' platforms are global in scale and allow hundreds of millions or billions of people to upload vast quantities of information on a daily basis. Yet there are no allegations that the defendants treated ISIS any differently from anyone else. Rather, defendants' relationship with ISIS and its supporters appears to have been the same as their relationship with their billion-plus other users, arm's length, passive, largely indifferent. And their relationship with the RENA attack is even further removed given the lack of allegations connecting the RENA attack with ISIS's use of these platforms. Second, because of the distance between defendants' acts or failures to act and the RENA attack, plaintiffs would need some other very good reason to think that defendants were consciously trying to help or otherwise participate in the RENA attack. But they have offered no such reason, let alone a good one. Again, plaintiffs point to no act of encouragement, soliciting, or advising the commission of the RENA attack that would normally support an aiding and abetting claim. Rather, they essentially portray defendants as bystanders watching passively as ISIS carried out its nefarious schemes. Such allegations do not state a claim for culpable assistance or participation in the RENA attack. Because plaintiffs' complaint rests so heavily on defendants' failure to act, their claims might have more purchase if they could identify some independent duty in tort that would have required defendants to remove ISIS content. But plaintiffs identify no duty that would require defendants or other communication-providing services to terminate customers after discovering that the customers were using the service for illicit ends. To be sure, there may be situations where some duty exists, and we need not resolve the issue today. Even if there were such a duty here, it would not transform defendants' distant inaction into knowing and substantial assistance that could help establish aiding and abetting the RENA attack. If there were any doubt, the expansive scope of plaintiffs' claims would put it to rest. Given the lack of any concrete nexus between defendants' services and the RENA attack, plaintiffs' claims would necessarily hold defendants liable as having aided and abetted each and every ISIS terrorist act committed anywhere in the world. Under plaintiffs' theory, any U.S. national victimized by an ISIS attack could bring the same claim based on the same services allegedly provided to ISIS. Plaintiffs thus must allege that defendants so systematically and pervasively assisted ISIS that defendants could be said to aid and abet every single ISIS attack. Viewed in that light, the allegations here certainly fall short. Plaintiffs do not claim that defendants intentionally associated themselves with ISIS operations or affirmatively gave aid that would assist each of ISIS terrorist acts. Nor have they alleged that defendants and ISIS formed a near-common enterprise of the kind that could establish such broad liability. These allegations are thus a far cry from the type of pervasive, systemic, and culpable assistance to a series of terrorist activities that could be described as aiding and abetting each terrorist act. To be sure, We cannot rule out the possibility that some set of allegations involving aid to a known terrorist group would justify holding a secondary defendant liable for all of the group's actions, or perhaps some definable subset of terrorist acts. There may be, for example, situations where the provider of routine services does so in an unusual way or provides such dangerous goods or wares that selling those goods to a terrorist group would constitute aiding and abetting a foreseeable terrorist attack. Or if a platform consciously and selectively chose to promote content provided by a particular terrorist group, perhaps it could be said to have culpably assisted the terrorist group. In those cases, the defendants would have arguably offered aid that is more direct, active, and substantial than what we review here. In such cases, plaintiffs might be able to establish liability with a lesser showing of scienter, but we need not consider every iteration on this theme. In this case, it is enough that there is no allegation that the platforms here do more than transmit information by billions of people, most of whom use the platforms for interactions that once took place via mail, on the phone, or in public. The fact that some bad actors took advantage of these platforms is insufficient to state a claim that defendants knowingly gave substantial assistance and thereby aided and abetted those wrongdoers' acts. And that is particularly true because a contrary holding would effectively hold any sort of communication provider liable for any sort of wrongdoing merely for knowing that the wrongdoers were using its services and failing to stop them. That conclusion would run roughshod over the typical limits on tort liability and take aiding and abetting far beyond its essential culpability moorings. In holding that plaintiffs had stated a claim, the Ninth Circuit went astray through a series of missteps that together obscured the essence of aiding and abetting liability. To correct these errors, we proceed through the Ninth Circuit's application of Halberstam's framework. The Ninth Circuit framed the issue of substantial assistance as turning on defendants' assistance to ISIS activities in general. But as we explained above, the question is whether defendants gave substantial assistance to ISIS with respect to the Rena attack. The focus thus must remain on the Rena attack. Plaintiffs' failure to allege any definable nexus between the defendant's assistance and that attack, therefore, at a minimum, drastically increases their burden to show that defendants somehow consciously and culpably assisted the attack. Next, the Ninth Circuit misapplied the knowing half of the knowing and substantial assistance phrase. It first separated the knowing and substantial assistance subelements, and then it analyzed the knowing subelement as a carbon copy of the antecedent element of whether the defendants were generally aware of their role. So, knowing means they're generally aware of their role, according to the Ninth Circuit. But as discussed above, the knowledge and substantial assistance components should be considered relative to one another as part of a single inquiry designed to capture conscious and culpable conduct. The knowing part of that inquiry is therefore designed to capture the defendant's state of mind with respect to their actions and the tortious conduct, even if not always the particular terrorist act, not the same general awareness that defines Halberstam's second element. So two different knowings. Finally, when applying Halberstam's 6 substantiality factors, the Ninth Circuit appears to have regarded the factors as a sequence of disparate, unrelated considerations without a common conceptual core. This is incorrect. The point of those factors is to help courts capture the essence of aiding and abetting, participation in another's wrongdoing that is both significant and culpable enough to justify attributing the principal wrongdoing to the aider and abetter. The Ninth Circuit thus erred in focusing, as it did, primarily on the value of defendants' platforms to ISIS, so the value of the defendants' platforms to ISIS, rather than whether defendants culpably associated themselves with ISIS's actions. For example, when applying the second factor, the amount and kind of assistance, the Ninth Circuit should have considered that defendants' platforms and content sorting algorithms were generally available to the internet using public. That focus reveals that ISIS' ability to benefit from these platforms was merely incidental to defendants' services and general business model. It was not attributable to any culpable conduct of defendants directed towards ISIS. And when considering the fourth and fifth factors, the defendant's relationship to ISIS and the defendant's state of mind, the Ninth Circuit should have given much greater weight to defendants' arm's-length relationship with ISIS, which was essentially no different than their relationship with their millions or billions of other users, and their undisputed lack of intent to support ISIS. Taken as a whole, the Ninth Circuit's analytic approach thus elided the fundamental question of aiding and abetting liability. Did defendants consciously, voluntarily, and culpably participate in or support the relevant wrongdoing? As we have explained above, the answer in this case is no. Plaintiffs allege only that defendants supplied generally available virtual platforms that ISIS made use of, and that defendants failed to stop ISIS despite knowing it was using those platforms. Given the lack of a nexus between that assistance and the Rena attack, the lack of any defendant intending to assist ISIS, and the lack of any sort of affirmative and culpable misconduct that would aid ISIS, plaintiffs' claims fall far short of plausibly alleging that defendants aided and abetted the Rena attack. That leaves the set of allegations specific to Google. As explained above, plaintiffs allege that Google reviewed and approved ISIS videos on YouTube as part of its revenue sharing system, and thereby sharing advertisement revenue with ISIS. Yet this still bothers me to this day, the way YouTube will flag like creators' videos for the slightest little thing, but advertisers' videos can have all sorts of things wrong with them and go through. Why aren't we applying the same standard to creators' videos and to advertisers' videos? I understand why, money, but why is that right? Why is that morally okay? It's not morally okay is the answer, in my opinion. The Ninth Circuit briefly mentioned those allegations when analyzing plaintiff's complaint here. However, in addressing another materially identical complaint, the Ninth Circuit held that the same allegations failed to state a claim for aiding and abetting liability because they were devoid of any allegations about how much assistance Google provided, and therefore did not plausibly allege that Google's assistance was substantial. We think that the Ninth Circuit was correct in that holding. The complaint here alleges nothing about the amount of money that Google supposedly shared with ISIS, the number of accounts approved for revenue sharing, or the content of the videos that were approved. It thus could be the case that Google only approved one ISIS-related video and shared only $50 with someone affiliated with ISIS. The complaint simply does not say, nor does it give any other reason to view Google's revenue sharing as substantial assistance. Without more, plaintiffs thus have not plausibly alleged that Google knowingly provided substantial assistance to the Rena attack, let alone every single terrorist act committed by ISIS. By their very nature, the concepts of aiding and abetting and substantial assistance do not lend themselves to crisp, bright-line distinctions. However, both the common law and Halbertstam provide some clear guideposts. The point of aiding and abetting is to impose liability on those who consciously and culpably participate in the tort at issue. The focus must remain on assistance to the tort for which plaintiffs seek to impose liability. When there is a direct nexus between the defendant's acts and the tort, courts may more easily infer such culpable assistance. But the more attenuated the nexus, the more distant, the more courts should demand that plaintiffs should show culpable participation through intentional aid that substantially furthered the tort. And if a plaintiff's theory would hold a defendant liable for all the torts of an enterprise, then a showing of pervasive and systemic aid is required to ensure that defendants actually aided and abetted each tort of that enterprise. Here, however, the nexus between defendants and the Rena attack is far removed. As alleged by plaintiffs, defendants designed virtual platforms and knowingly failed to do enough to remove ISIS-affiliated users and ISIS-related content. Out of hundreds of millions of users worldwide and an immense ocean of content from their platforms. Yet plaintiffs have failed to allege that defendants intentionally provided any substantial aid to the Rena attack or otherwise consciously participated in the Rena attack, much less that defendants so pervasively and systemically assisted ISIS as to render them liable for every ISIS attack. Plaintiffs accordingly have failed to state a claim. We therefore reverse the judgment of the Ninth Circuit, it is so ordered, and that's the unanimous decision of the U.S. Supreme Court. There is a 1-paragraph or 2-paragraph concurrence by Justice Jackson. I join the opinion of the court with the understanding that today's decisions are narrow in important respects. In this case and its companion, Gonzalez, the court applied 2333 to two closely related complaints filed by the same attorney. These two cases were filed by the same attorney as well. Both cases came to this court at the motion to dismiss stage with no factual record, and the court's view of the facts, including its characterizations of the social media platforms and algorithms at issue, properly rests on the particular allegations in those complaints. So the court did not hear outside evidence. Other cases presenting different allegations and different records may lead to different conclusions. The court also draws on general principles of tort and criminal law. General principles are not universal. The common law propositions this court identifies do not necessarily transfer or translate into other contexts. So I think Justice Jackson is trying to distance this case from major precedent. So yeah, this case is precedential. You can cite this case, but you're going to be citing it for something narrow, for this exact case, not for some side case. I think this is the right result. I don't really see how YouTube or Google or Twitter or Facebook are liable for ISIS terrorist attacks, even if ISIS used their messaging system or their social media network to plan and carry out the attack. If Facebook knew that there was going to be an attack and had some duty, sure. Let's make a law that imposes some duty on Facebook to notify when it's aware of something. It'll hurt Facebook. It'll hurt social media. We have to make those choices, and that's part of the philosophy of putting limitations on things like speech. So here you have fully unfettered free speech, and I know it's not fully unfettered, but here ISIS has their free speech, and look what they can use it for. So unless you're going to figure out how to limit it for ISIS and everyone else, that's going to happen. And why would Facebook or Google or whatever be liable for someone using a messaging service? Not liable for using the telephone to commit a crime. I mean, the telephone company isn't liable. The car company isn't liable when you use your car to commit a crime. The water company isn't liable when you drown somebody. You know what I mean? Like when you fill up your bathtub and drown somebody. You know what I mean? Like you get it? Like, okay, so maybe the social media company is a little more tangible as far as the aiding and abetting than like the water company providing the water. The social media company knows that ISIS is using their services. The grocery store knows that ISIS is buying groceries and sustaining themselves, and then they're able to carry out terrorist attacks. Can we sue the grocery store? Okay, so maybe the grocery store is maybe not the same as a social media company, but we're getting there, right? Like if we're going to try and sort of shoot and see where we hit with different examples, the grocery store is pretty close. So, if ISIS is using Facebook and Facebook is favoring ISIS over other users, I think you're much closer to an aiding and abetting claim. If they're just treating you like they treat everybody, sounds defensible to me. I don't personally or professionally see how that's aiding and abetting. And I don't think I would have interpreted this law as establishing aiding and abetting liability to a social media company who knowingly hosts but otherwise doesn't assist a terrorist organization that also carries out terrorist attacks. Anyway, let me know what you think of that one in the comments below. And thank you to my supporters. This is a community-supported legal education channel. I don't do advertising. I don't advertise VPNs to you. I don't advertise streaming channels to you. Thank you in the month of May to Eevi, Ugly Grill, Torpedan, PureMagma, Eric Tams, TechTechPotato, Gutbrodj, King Aries, The Blood-Soaked Survivors, Kyle Siefring, and don't credit or shout out this account. Anyway, love you all. I'm going to go. Have a good week. Bye.